From the Library of Congress in Washington, D.C.
So panel 2 is called the Rulemaking Process, Evidentiary and Procedural Issues. So if this is what you're here for, you're in the right place. I'd like to start for us briefly introducing ourselves. First, from the Copyright Office, I'm Reagan Smith, Associate General Counsel.
Kevin Amer, Senior Counsel for Policy and International Affairs.
Andrew Moore, Ringer Fellow. Jason Sloan, I'm an Attorney Advisor in the General Counsel's Office.
And now if the parties would like to introduce your names and an organization you represent.
Krista Cox, the Association of Research Libraries.
Peter DeSherney from the University of Pennsylvania.
Robin Green from New America's Open Technology Institute.
Chris Moore, SIA. Matt Williams from the MSK Law Firm for the Association of American Publishers, the Motion Picture Association of America, and the Recording Industry Association of America.
Rebecca Tushnet, the Organization for Transformative Works.
Bruce Turnbull, representing the DVD Copy Control Association and the Advanced Access Content System Licensing Administrator, LLC.
Raza Pinjwani, Public Knowledge.
Great. So this panel is to explore the general operation of the triennial rulemaking process. I see that many of the panelists are participants in the process, and so they're probably aware that last October concluded the 6th process, where the office received 44 petitions. We grouped this into 27 categories of exemptions. The registrar recommended and the librarian adopted the granting of 22, but through that process, the office received nearly 40,000 written comments, and we understand in the comments written in support of this study, for many participants, it was seen as taking a lot of time and perhaps a disproportionate amount of time. The comments and testimony that we received in the last rulemaking reflected considerable efforts from individual participants, nonprofit organizations, law firms, legal clinics, and industry members. And we're interested in hearing your thoughts about the procedural aspects of the rulemaking, as well as the evidentiary standards that are applied. And keep in mind, some of you will also be on panel 3, but that topic is whether or not there should be some sort of presumptive renewal or streamlining for renewals of exemptions that are granted. So we're going to try to respect that that's the topic of the next panel as opposed to this panel. So I think to start out, I'll just ask a very broad question for those that have participated in the process. How do you find it's working for you? And in the answers, please just tip your placards up if you wish to speak. And if you could please try to keep your response to maybe 2 to 3 minutes, we'd appreciate it. Thank you. Professor Tushnet?
So, not so well. So we dedicated really probably 500 to 600 hours if I look at my time, which I don't keep with the same regularity you would at a law firm. And several other people, other lawyers volunteering for my organization also dedicated significant time, as well as conversations with technical people and other people and some of our members who take advantage of the exemption. So it was a big deal, and there are significant problems with the requirements that the office currently imposes. I think the cyber law clinic's comments go into great detail, and I'm largely in agreement, so I won't run through there. I would say one specific issue in particular that doesn't work well. So for 3 rounds, we have made the argument that the Copyright Office should consider actual knowledge and behavior among potential users of an exemption when interpreting whether there are alternatives to circumvention. That is, it should consider whether these alternatives are in fact known and used. And frankly, it's quite frustrating that the Copyright Office has not even addressed this argument, much less given a reason why it has rejected this argument, which we could actually then talk about. It's also contrary to the due process principles and the notice and comment practice of rulemaking. And, I'd just like to hear something from the Copyright Office about that.
Okay, Mr. Turnbull?
My clients have participated, DVD-CCA, in all of the prior rulemakings in ASCS in the last couple. And I would say, in general, we actually find that it works well. I think the basic approach is correct, that that those who seek the exemption have the information that's necessary to bring forward, and that's how it has been put forward. I think and the notion that the basic presumption is that the prohibitions are to stand unless there is evidence brought forward sufficient to demonstrate the need for the exemption is the correct approach. I think that there are details about how many rounds of submissions there are, whether the initial round in the last rulemaking was necessary or additionally burdensome. I think from the responding party's point of view, we wound up with one response, one opportunity, whereas other participants, the proponents, had multiple. And so again, in the details, I think there are places that could be improved, but as an overall matter, I think we find that it works well.
If I could ask if you could turn off your microphone when you're done speaking, that will just help prevent feedback noise. And also a follow-up to Mr. Turnbull, did you feel as participating in the second cycle of comments and there not being a fourth that, there was something you had left unsaid, or did you feel you had the opportunity to express your viewpoint on all issues?
Well, the concern largely was that, I understand the inclination of proponents to bring forward evidence or information, in response to what was submitted. But we really, other than through the hearings, which was an imperfect way of doing it, partly because of the time limitations and the questions and that sort of thing, there were things in the responding round from the proponents that one would have liked to have had an opportunity to respond to. I mean, there are different ways that could be handled. I mean, the Copyright Office could be more vigilant in saying no to new submissions of new evidence, or giving another round, or other ways. But I would say that there were, particularly in this last proceeding, there were times when we would have responded if we had the opportunity.
Okay, thank you. Mr. Panjawi?
There are a number of aspects of the proceeding that we've been involved in that we've highlighted as problematic. In fact, we filed general comments at the outset of the last triennial process to highlight some of the issues we had, beginning with the identification of classes of works under Section 102 for exemption process, the standard of identifying non-infringing uses, as well as adverse effects. I particularly want to focus on the first two, in part because, as Professor Tushnet mentioned, the Cyber Law Clinic's comments on the adverse effects, I think, were very appropriate and sort of addressed that very thoroughly. Currently, the approach to identifying classes of works results in, as alluded to in the prior panel, some distinctions that don't quite make sense. So, for example, the difference between tablets and phones that involve the same exact software, thus bifurcating the docket and require filings in both cases. The differentiation between users, educators, by differentiating the class of users, either K through 12 educators or higher education educators, which it's unclear where these distinctions in terms of classes of work come from, or the differentiation in granting an exemption between a Blu-ray disc and a DVD disc as a user. Beyond that, in terms of the burden that we find as problematic in terms of filing, identifying non-infringing uses, is that the expectation that proponents must identify affirmative precedent affirming a non-infringement, whereas the dearth of precedent identifying an infringing activity does not satisfy the burden. This is particularly problematic because without an exemption, a party cannot engage in the activity, which means that there is a lack of an opportunity for case law to develop in that space. In fact, I would characterize the lack of an exemption in some areas as effectively denying courts jurisdiction to define the contours of infringement in that particular area. If you cannot circumvent for purposes of engaging in an activity, there's no way of defining one way or the other whether that's actually infringing in a court's eyes if there is no case law on that point. I have other
Okay,
areas,
well,
but I'm gonna
I think
stop
you've
there.
raised a lot of issues, and some of those we'll begin to drill deeper to, but I do want to give everyone an opportunity to speak a little bit opening. And I think one of the things to consider maybe as we continue going around is to what extent are some of these issues that you're raising sort of dictated by the statute, which requires a finding that an activity is likely to be non-infringing. So Ms. Cox?
So the Association of Research Libraries has participated in the rulemaking process as part of the Library Copyright Alliance. And the process is just, it takes an extraordinary amount of time. As Professor Tichenant mentioned, it took them like 500 to 600 hours. We're very lucky to have the assistance of some of the clinics that we've worked with and joined in some of their filings, because otherwise it really does take an extraordinary amount of time and resources where you have to assemble the evidence, you have to submit the proposal, including the text, you have to basically write a brief on why your use is non-infringing, and you have to then respond to any opposition to those proposals, prepare a written reply, participate in the hearings, and then do the follow-up questions. And this whole process can take a year or more, which is just an extraordinary amount of time for something that is proposed by public interest groups that often don't have the time or resources to invest in this. And this is why we are very grateful to the clinics. Just on Roz's point about that the lack of exemption denies courts these opportunities, it really does make putting together this evidence very, very difficult. It makes writing these briefs on why it's a non-infringing use, it can make it more difficult. And as Mr. Turnbull said, he believes that those who want the exemptions have the opportunity and the information necessary. And I would disagree, just to the extent that this process really provides an asymmetry of interests, where these corporations are usually the ones that are opposing these exemptions, whereas it is these public interest groups that don't have these resources needing to walk through this very complicated and burdensome and very formalistic system.
Mr. Moore?
A couple of preliminary points. The first thing is, I think I want to be clear in distinguishing between, let's say, problems with the statute and problems with the rulemaking. There are, in our mind, there are areas where, in fact, overall, the statute is working quite well. And I think in the comments from AAP and the MPAA and also in ours, we try to give some examples of how new business models have been encouraged. This was designed to be a fail-safe, and it was designed to operate in a certain way, and I think you hit on that, and that is specifically with respect to the statute, that the statute has to be a source of causation of the harm. It can't be alternative distribution models. It can't be the fact that something is inconvenient. It has to be the statute that is causing the adverse effect, and I think to the extent that the rulemaking has gone off the rails a bit, it might be useful to examine how closely the library is hewn to that particular standard.
Can you elaborate if you think that the rulemaking has gone away from the standards set out in the statute?
Well, initially, I mean, it's changed. The library has changed its position. I mean, in the initial rulemaking, the very first one, there was a fairly large fight over whether or not an exemption should issue to a class of user or to a class of works. The initial rulemaking tried to stay pretty close to that line. And I think later it got much more into the class of user, and then it got a lot fuzzier. I think there are places where there may be other statutes, for example, that prohibit a particular course of conduct. And so, assuming both statutes are valid, assuming both statutes prescribe the same conduct, the Section 1201 can't be prescribed as a cause. It's a way, the proceeding is being used of validating some other policy goal that they would like to have, but has nothing to do with copyright. In that particular instance, I'm not sure that issuance of an exemption is appropriate. In other words, tie goes to no exemption. Those are the sorts of things I mean by statutory causation, if you like.
Mr. Williams?
Thank you. Thank you. I'd like to reiterate first what Mr. Turnbull said in the sense that, the comments by their very nature kind of contain a lot of criticism of what the office has done, but I think you guys also deserve a good bit of praise for taking a tricky statute and making a proceeding that's overall worked quite well. I think we're in kind of a, it's not broken, so you have to be very, very careful trying to fix it scenario. Again, it's functioning as it was intended to. We're not always happy with the outcomes. We're frequently unhappy with some of them. And we've got a few things in our comments that we think could be improved. One important one, I think, is we would love to see a draft of the regulatory language in advance of it being published, just so that everyone who participated in the hearings at least can comment on the drafting choices. But some of those things are relatively minor improvements that we think could be made. And overall, we think things are working pretty well. On Bruce's point about the one filing versus 3 from the last cycle, we also felt that there were some things left unsaid. Part of that was because at the hearings, I think, as you should, you gave the proponents a lot of opportunity to explain their cases, and then us who were sitting at the end of the table ended up running out of time sometimes, so having one more written filing might have been helpful. I just have a very few brief things in response to some of what's being said. I think public knowledge raised the issue of why should we be distinguishing between different types of users, and I think that's something that grew out of what Mr. Moore was talking about, which is that we've altered the approach somewhat in that a class of users was not something that was initially being looked at. But overall, I think my clients have come to find that change has been helpful. It's not perfect, and we do have some concerns about how it works. But overall, I think we have found it to be helpful. And so in the previous panel, Jonathan Band was raising the issue of, well, this is going to keep growing and growing and growing, and eventually the whole building is going to have to work on it. But I think that is in large part the result of the office trying to be accommodating to the proponents and trying to let them make their case, and expanded the approach to allow the class of works definition to be altered. And so sometimes you have to take a little bit of bad with a lot of good. And so that, I think, is kind of why the proceeding has grown the way it has. The last point I wanted to respond to was this issue that 1201 supposedly inhibits the development of normal copyright case law or fair use case law. I've never understood that argument, and I still don't understand that argument. I understand that there are two different types of liability, and that in counseling a client, you have to address both. On the other hand, if there are the number of threats that people claim there are of 1201 liability, there are lots of ways to pursue declaratory relief actions without connection to the 1201 threat and still pursue your copyright arguments. There are lots of fair use cases going on out there. I'm involved in a lot of them on both sides, often on the defense. There are a lot of other types of exceptions-related cases going on that have nothing to do with 1201. So I don't believe that the case law is being inhibited. Thank you.
Okay, well, we did open up with a broad question. I think now we've got a lot of issues to unpack. So I think the I might be hopping around a little bit, but on the question of how to define a class of works, it is true, as others have mentioned, that in the first rulemaking, the office did not define a class of works by reference to the users, but subsequently from the second rulemaking on, it has. And my question is, if this were to be taking an opposite approach and not allow refining it by the types of users or uses, would this be likely to result in perhaps less exemptions? What effect would this have on the rulemaking if you need to look at sort of a wider pool in terms of whether an activity is likely to be non-infringing? So Professor Deckerney?
Yeah, thank you. So I've been participating in the rulemaking since 2006 when it was, when the use and users were added to the definition of class of works. I think it's not a question of whether or not it becomes larger or smaller as a class, but it brings the idea of a class much more in line with fair use, which is about use and users. And of course, all non-infringing uses aren't about fair use. There are plenty of kinds of non-infringing use which are about exemptions like 110, but fair use obviously is a really important one. So I think it actually makes the logic of the arguments much cleaner and brings them into line with fair use. We're not talking about video games that can only be played on obsolete technology, but it's about use by archivists, which is really what that exemption was meant to be used for, going all the way back to 2003 and 6. Could I add a few other comments from the
Sure,
first
go
round?
ahead.
So, I mean, in some ways, the rulemaking has I think, really been effective. And from my own perspective, many, thousands of educators and students have been able to engage in non-infringing uses as a result. And there are so many changes that have helped that, including the added addition of use and users and the streamlining of the process. So I'm happy to see that you're open to new changes. I mean, just to bring up two small issues, or two issues, not so small. One is the emphasis that we place on the next 3 years in each rulemaking. Often we end up debating things that end to be vaporware, technologies that never materialize, licensing agreements which are still being negotiated even 16 years after we first heard about them. And if there's a way to keep that to things that are tangible and real and that there's evidence that they exist, would be terrific. The other is what we're going to talk about this afternoon, which is the renewal process. And so I'll put that aside, but I'd love to rethink what de novo might mean and whether or not we need to use that standard at all. But also maybe something more appropriate for this part of the hearing is how evidence is preserved and used and then maybe reused for the future.
Yeah, and keeping in mind that the next panel is going to talk about renewals, like if there were some type of reform for renewals, it seems like it might take some of the pressure off the participants in each of the rulemakings going anew. But Mr. Panjwani, I think am I saying that right? Okay, Panjwani.
I'd also like to just respond very briefly to some of the points made previously. It was already mentioned the amount of hours that had to be put in by proponents, ranging from 500 by a few of the clinics to as high as, I believe, 2,000 hours was the number listed in the reply comments by the filmmakers, by the UC Irvine Law Clinic, as well as their pro bono counsel. I don't think a system that relies on pro bono counsel and the availability of clinics is sustainable. I know Mr. Williams doesn't believe that we're going to have necessarily this proliferation, but one example that came up was consumer appliances and the software embedded in them are not covered by any of the exemptions, and we're going to have to wait 2 years to deal with that, and that's going to be an additional class that's going to require addressing an additional proponent work. In terms of the specifics of the comment periods of the process, I will note that in my limited experience as a litigator in motion practice, typically the party with the burden of proof is allowed to file in favor and a reply brief, and reply briefs, a fourth round, is typically not given as of right. I would also note that it's important to realize that the burden, as we often hear from the Copyright Office, the burden is on the proponents to the point that there's no such thing as a default judgment in favor of proponents. It is possible to have your exemption denied without anyone actually opposing it, as the Register recommended the denial of the ebook reading exemption back in 2010 without any substantive opposition. I would also note that the problems with the process in terms of accessibility to the public and understanding what's going on were delineated in the cyber law clinic's comments that pointed out that there are effectively 9 factors that the office considers. You cannot find those 9 factors listed in one place, but rather one must parse both the original NOI requesting classes being identified, and in the NPRM calling for the rulemaking process. And in combination, one gets this multi-factor test that is highly technical and requires all these hours to actually meet.
I'm just going to move on so we can facilitate this. Again, I think that these issues end up being a bit intertwined, but I'm trying to focus it, to narrow it. I wonder, can we get back to the question of the definition of the class of works?
So I understand the difficulty the office has in that they're asked to define classes of works, but exemptions must be granted for non-infringing uses. And then connecting those two perhaps leads to some of the difficulties that we have. I would say that there is a middle ground, though, between the atomization that currently occurs in the defining of classes and those Section 102 classes. I believe that we veered too far in terms of where we are. I think motion pictures for classes of fair uses as opposed to particular types of formats, I think, is where we start running into sort of shallow waters and fear of running aground. I think software also presents some difficulties in terms of tying it to a particular type of device, whereas perhaps software needs to be treated as its own class. That is, in fact, a narrower subgroup than literary works. So I would urge perhaps a movement away from the level of specificity currently in the definition of classes.
Thank you. Professor Tushnet?
So what was just said is exactly what I think about the classes too, especially since the burden placed sometimes doesn't inform us exactly, how specific we have to be. Right now, we have no reason to think or understand why, the exemption isn't for the University of Pennsylvania instead of for college professors. Because it's somebody from the University of Pennsylvania who's coming and asking. And so from our perspective, it is hard to understand what the distinctions are when we see someone testifying about the need of teachers across all disciplines. Then it turns out because they are actually from media studies, we only get an exemption for media studies. And so the part of the reason you've seen such an explosion is that we have learned the lesson that we have to bring sort of a kindergarten teacher and a first grade teacher and a second grade teacher. And this is, because you, in the past, the office has rejected, for example, when I bring in remix videos, they've rejected the relevance of the National History Day people who do make remix, but they make it in an educational context, so they don't count, apparently.
I do want to push back a little bit on the idea that you need to bring a kindergarten teacher, a first grade teacher, and a second grade teacher. I mean, and what would be the alternative? Would it be that, Professor Deckerney, shows, and the office has said this is a great example of fair use in cinema studies, and so he testifies about his need and exemptions granted, and it is for fair use for all motion pictures. Where would the line be drawn?
Motion pictures in educational context, absolutely. Because what he testifies about is pedagogical practice. And certainly the people that we have, so Renee Hobbs, for example, she's actually not just a media educator, she actually works in the pedagogy of education. And so that's the kind of thing where the evidence in front of you actually supports the generalization being offered, because it's about how pedagogy works, not about how media studies in particular works, or language studies, or film studies. And we think that a similar level of generality, similar to what you see in fair use cases, right? So people in fair use cases, they list education, criticism, commentary. They don't say media studies. And there's a reason for that. And I think that that kind of change could really help decrease the burden on you, as well as align it, as Raja was saying, more with the needs, the statute.
Mr. Turnbull?
Well, far be it from me to advocate for exemptions, but I really think that the focus on K through 12 or particular types of higher education has enabled the office to make recommendations for exemptions, whereas a much broader category, as had been in the early rounds, resulted in no exemption recommendation, and that if you again, if you start out with the proposition that the default is that the prohibition on circumvention shall apply, which is what the statute and the legislative history tell you, unless there is a particular body of evidence saying that a particular use is being frustrated by the particular technology involved, then if you have a broader category, you're much more likely to find that no, in the broader category, there's not the frustration of the use. Whereas if in a narrower category, I mean, Professor DeCherney did a really superb job in 2006 of explaining why it was that he needed what he needed. And I think that the evidence that's been presented in other cases, well, again, with Mr. Williams, I'm not always happy with the result. I think that has been a reasonable outcome based on what's been presented. And if there are ways to make that a little easier for some of the proponents, I'm not opposed to that, but I think that the way the categories are defined has in fact enabled the granting of certain exemptions that in a broader category would not have been granted.
Mr. Williams?
Thank you. Yeah, I agree with Bruce. I think your question was if the approach to class of works changed, would that end up resulting in fewer exemptions? And I think if you followed the approach as you have and only altered that portion, that it would, because you, as you said, need to decide that the use is likely non-infringing. I actually think you have to go farther than that. You have to decide that it is non-infringing because the statute says likely adverse impact. It doesn't say likely non-infringing use, but that's a disagreement I have. But in order for you to make that conclusion, even that it's a likely non-infringing use, you have to start engaging in some of the line drawing that is being criticized. So you've done things like focus on use of short portions of works for criticism and commentary in non-commercial sectors. Those things help you get to the conclusion that what the proponents want to do is a lawful use, and you have to get to that conclusion before you can grant the exemption. You also have to get to the conclusion that there are not reasonable alternatives available. So you have to draw the lines that were being criticized between different formats, because just because someone who's engaged in a certain activity wants to use DVD quality footage, that doesn't mean that they have to have Blu-ray quality footage. And so the line drawing that you've engaged in, I think, has allowed you to craft exemptions that comply with the statutory requirements and that also give the proponents a lot of what they're asking for. So I would be careful playing around with doing away with some of this line drawing. A couple of very quick responses. On the burden of proof issue, I think this was heavily debated in the 2000 rulemaking and then all over again in the 2003 rulemaking. There were a lot of disagreements at that time between NTIA and the office as to how to read the statute. One thing they both agreed on, though, was that the burden is on the proponents and that that's a requirement in the legislative history. And Federal Register 65, page 64558 goes through the office's initial reasoning as to why the burden needs to be on the proponents, and I think it's sound reasoning even to today, citing case law and other sources that basically say that when you're dealing with an exception to a general rule, the burden is on the proponent of the exception to make its case. So I'd urge you to go back to that. I think I'll end there.
Okay, Ms. Cox?
So I agree with a lot of what Raza and Professor Tushnet said, that I think, and Professor Deschanel, that defining based on uses really does make a lot of sense, that it does put it in line with fair use. And I think that distinguishing between the different educational uses between K through 12 or, media studies or other disciplines in college really doesn't make a lot of sense, because we are talking about pedagogy, we're talking about educating students. And I would just say that trying to draw all of those distinctions actually makes the actual text of the exemptions not as usable, not as friendly. For example, in the most recent rulemaking process, the exemption for film clips was 1,055 words long. The 2006 exemption was 44 words long. A 44-word exemption is a lot easier for the average teacher or person, user to understand versus having to really parse through the statute and really understand what is allowed or what's not allowed. So I think that if you went back to looking at the uses instead of, the classes of users, I think that it would make it easier for us to understand it and you wouldn't go through such a long and drawn-out process.
Okay, thank you. Ms. Green?
Thank you. I just wanted to respond. This is a little bit off topic from your question directly, but to what Mr. Williams was saying about the proper interpretation of whether or not something is infringing. And it is our position that the Copyright Office should be uniformly applying a standard that they merely have to find that a proposed exemption is likely non-infringing. We think that this emanates directly from the statute, as the Cyber Law Clinic at Harvard stated as well in its comments. Our view is certainly in line with that. And we would also urge a narrow interpretation of the question as to whether the proponent of the exemption experiences adverse effects as a result of the TPM. We think that both of these would be in keeping with the intent of the statute and would allow for a better implementation of the rulemaking process.
Professor Docherty?
Just to quickly set the record straight when I'm criticized by Professor Tischnet and praised by Mr. Turnbull. In 2006, we did actually apply for an exemption for media professors. Immediately, we were criticized by everyone who said, what about us? We also need an exemption. And as a result, had evidence from people across the academy and lots of stories from people in many different fields, but also support from many different professional organizations, including the American Association of University Professors, the largest organization of academics, and so who are all represented by me normally during the rulemakings, not today, although they have submitted comments actually. So it is a broad exemption. I just one quick point about what Mr. Williams was calling the line drawing, and I think this relates to Ms. Cox's comments as well. But we are often talking about these distinctions between DVD and Blu-ray, and it's not about non-infringing uses versus non-infringing uses, infringing uses, but about the level of need, of quality, what constitutes something that's useful for education or for archiving purposes, and it's not clear exactly what the standard is there. I mean, I know you want to be convinced by us that it's something we need, but I think some kind of clearer understanding of what that bar is would be terrific.
Thank you. So the next area I'd like to tee up is the burden of proof, which some have already sort of spoken about. Mr. Williams has quoted what the office has said in the statute, says the librarian needs to make a finding of something that's specifically going to happen in the next 3 years. So I think there's two sides to this question. First is the office has said that the burden of proof is on the proponent, and we've also heard that it's taking legal clinics hundreds of hours. So there's both a substantive and a procedural angle to this question. Should the office institute reforms that give people less opportunities to submit evidence? Would that hurt the ability for proponents to obtain an exemption, or are there specific reforms we should consider? Mr. Moore?
I think there are certain things, I think there are certain things you might be able to do through concepts of administrative notice that would streamline the proceeding. I think it's totally reasonable for someone who has proven an exemption to provide information in abbreviated form, for example, that they have used the exemption. It would certainly be helpful to say, yes, we've used this. And here's a couple of brief examples of the kind of thing that we've done. I'm not talking about a 300-page, 1,000-footnote filing. This is what I did with my summer vacation, that kind of thing. And provided that's all that's being sought is the exact same exemption from the year before, that should be enough unless somebody else comes forward and says, no, things have changed, the exemption is being abused, there's some other evidence that, there was some flaw in the case beforehand that warrants a revisiting of this or something, a rebuttal, basically a rebuttal of that evidence. But the burden, you're right, the burden has to be on the proponent first. But after that, I think you as an administrative agency, as opposed to a court, have more flexibility in how you handle the rulemaking from that point as it goes forward.
Just to sort of focus a little bit on this question of what we as the office can do versus what might require statutory change on this question of the burden of proof. We have said that the proper showing is a preponderance of the evidence standard, which requires a more likely than not showing. Is there agreement that that is the proper sort of baseline framework that we should be applying, or do people have a view that that we have some latitude in that area? Mr. Panjwani.
I don't think we take, or at least speaking for public knowledge, we take issue with the idea of a preponderance of evidence standard for meeting the burden of proof as a proponent. I think, however, where our disagreement enters in is what that means with respect to each of the elements. What is showing non-infringing use by preponderance of evidence, and what are the adverse effects that the statute contemplated that proponents would be required to demonstrate in order to meet a preponderance of evidence standard?
Professor Tushnet?
So I was just going to say exactly what, exactly that. We should definitely not change the process to give us less opportunity to make our case. I think there would be serious due process problems with that, among other things. But the reason these submissions are 150 pages long is because of this question, burden of proof and the preponderance of evidence as to what? And again, I direct you to the cyber law clinic. The burden of proof should be about non-infringing use, adverse effects, not the 9 different things that the Copyright Office has come up with over time, which do contribute to the fact that we feel like we have to meet the burden on other considerations that may be added into the process later. And I think adhering to the statutory text could really solve a lot of that. Actually, could I actually respond to something earlier? Because I feel like I don't want to let it go. In terms of the question of 1201 interfering with the development of case law, so we heard that that didn't really happen. Let me offer you 2 pieces of evidence that it does. First of all is my own experience and that of the OTW as a whole. So we counsel remixers. Before the exemption happened, remixers often, well, not often, but occasionally would receive DMCA notices. We'd talk to them about whether they wanted to counter notice. And we always had to ask them before the exemption, how is this footage made? And because nobody knows about the DMCA, almost all of them made it by DVD ripping, because that's what gives you the most effective source. And nobody that I counseled thought, oh yeah, I should go ahead and make my fair use argument, even though I would be willing to go ahead and do that, because I'm definitely going to lose, right? You have to tell them, look, if you made it the wrong way, you're going to lose. It doesn't matter that you have a good fair use case.
So in that example, I mean, what is the alternative? It seems like it may be statutory reform, since the statute requires that the non-infringing uses exist as opposed to proponing case law, right? I mean, the earlier panel, we talked about Congress making a decision to protect access to copyrighted work separately.
Well, I'm sorry, maybe I wasn't clear. Before we succeeded the first time in getting the exemption, that's how I had to counsel people. Now, I can counsel people saying, go ahead. I don't have to ask them how the footage was created. Go ahead, do your counter notice, and if they sue, we'll represent you. And I'll tell you, no counter notice that I've worked with has ever proceeded to a case because remixers get takedowns that are unjustified, something that we've talked about in other fora. But at the very least, copyright owners have decided not to pursue claims when we thought there was a very strong fair use case. And we were willing to make that, which we couldn't do before we had our exemption.
Okay, so it sounds like the exemption in this case process was working, and then you could...
So in terms, right, now we are ready to make, right? We're ready to litigate some of the issues that before we existed, there was really nobody who would represent a non-commercial, most non-commercial cases don't end up in court because the defendant can't find a lawyer, right? We're now there to do that, and we're waiting for the right case, which we just couldn't do before. And then the other thing I would mention is the dicta in the Corley case, which has already come up, opining on stuff that's not before it, about the question of quality, like what, does fair use actually require a particular quality? So that's something that has been a real problem. It's explicitly disavowed by subsequent Second Circuit precedent, but it's still haunting us, as you can see by the fact that it's brought up 16 years later about whether you actually do have an entitlement to the right quality for your fair use.
Okay, Mr. Williams, I think if you wanted to respond to the initial question about burden of proof and preponderance of evidence.
Yes.
Okay.
On preponderance of the evidence, I think I saw a lot of confusion in the comments on what the standard means. And as you said, it means more likely than not, which is not a terribly difficult standard. It's the standard you're usually dealing with at trial. So if you show 51% and the other side's got 49, that's a close call, but you still win. So a lot of the comments seem to think it meant something quite different, and I think you could clear that up just by clarifying it. You've repeatedly done that in your NOIs. Every cycle you've explained what it means, but there seems to still be some confusion, and I think that might be because people get troubled by the substantial adverse impact standard, which is the burden they have to meet is to show that substantial adverse impact by a preponderance of the evidence. And you've also gone out of your way in every cycle to explain that substantial is not something that requires proof that something absolutely terrible has happened to you. It comes out of the legislative history that calls for distinct, verifiable, and measurable impacts, or that says mere inconvenience is not enough. All of those things were worked through in the 2000 cycle, and then in 2003, the office reiterated that it's not imposing any burden that isn't already in the legislative history by saying substantial. It's just saying, don't come to us with a hypothetical, don't come to us with a philosophical objection with the law. Tell us about a real-world issue, and we'll consider granting the exemption. So I think the burden has been handled properly, and that it's not something that should be changed.
Okay, thank you. I think we'll go to Ms. Green next, but one question is, does anyone want to specifically comment, thinking ahead, on the Breaking Down Barriers to Innovation Act, which would change statutorily and impose the totality of the circumstances test? So Ms. Green?
So I just wanted to respond to Mr. Williams' citation to the manager's report, and dependence on that as sort of the best source of legislative history. I would call into question whether or not those are actually appropriate standards. I mean, when you look at the actual statutory text, it does not impose any kind of substantial burden requirement. It says merely, as Mr. Williams was citing earlier, that the person be adversely, that someone is likely to be in the succeeding 3-year period adversely affected by virtue of the TPM. And so I do think the appropriate standard for inquiry is whether or not someone's proposed use is likely non-infringing, which would also be in keeping with the preponderance of the evidence standard, right? More likely than not. And then also seek to determine just whether or not, quite simply, something does impose an adverse effect as a result of the TPM, not imposing some type of heightened standard as to the level of that adverse effect. It's not clear in the statutory language or in the majority of the legislative history, as opposed to the sort of minority report by a single member of Congress, that there was contemplated any kind of like substantial adverse impact. It seems more likely, in fact, that that the intent was to determine whether or not there was any adverse impact, and then to err on the side of granting the exemption, as this was, of course, meant to be a fail-safe for people whose fair uses and other non-infringing uses would otherwise be made impossible as a result of 1201.
Okay, thank you. And I know a lot of the written comments do expose a lot of viewpoints on the legislative history too, and obviously we're taking those into account. And so on totality of the circumstances test, Mr. Panjwani, if you'd like to respond.
Sure. The Breaking Down Barriers to Innovation Act, best as I can recall it, offers a number of amendments by explicitly placing into the statutory factors for granting exemptions a lot of the things that we've talked about here. It is still our position at public knowledge that the statute can be interpreted to allow for many of those things, if not all of them. We can disagree on some of that. To focus again on the example you asked for about development of case law, one of the exemptions that we routinely ask for, and this is a bit of a sort of a Sisyphean gag between ourselves at public knowledge and Mr. Turnbull and Mr. Williams, is the DVD space shifting exemption, which we apply for every 3 years. I will note that while the Copyright Office disagrees with our analysis of the case law as to whether that is a non-infringing activity, NTIA in its report, looking at the same case law, comes to a differing conclusion. They also reach, I believe, in a disagreeing opinion with the Copyright Office as to whether narrative filmmakers are more likely than not to be able to make fair uses of video clips. And I think this highlights the problem that I talked about earlier about jurisdiction stripping, that we have two competent agencies reaching opposite interpretations of the copyright law, and that the appropriate authority to settle that dispute is a federal court. And the only way that gets to the court is if there is an exemption that allows us to settle the copyright issue. Because, sorry, go ahead.
Can I ask, how would you reform that? Would it be statutory reform? And the statute contemplates the librarian makes a determination based on the recommendation of the Registrar of Copyright, who in turn consults with NTIA, and so takes all that into account and, you know, puts into a final rule granting of exemptions. What would the reform be for that? Would you tip the scales, you know, in case of disagreement, or what would you propose?
I think the appropriate interpretation is that a preponderance of evidence standard applied to the non-infringement element is that barring affirmative case law saying that that activity is in fact infringing, that the tie goes to a determination of non-infringing as to that element. Because if the Copyright Office is wrong, rights holders have the ability to bring a case in court and settle that question and thus close off that exemption by finding of infringement.
So, I mean, just to be clear, it sounds like you're disagreeing with the outcome, but perhaps not the process. Is that right? Or?
In this particular example, I'm disagreeing with both. I think that if the process had worked appropriately, that the fact that there was a disagreement between the two agencies and the fact that there was no affirmative precedent that the ad activity was infringing should have resulted in that element coming out in favor of an exemption.
Thank you. Mr. Moore?
A couple of things. The first thing is the first thing is that, and I think it goes, you know, it does go kind of this proof question is, and the legislative history is that my friend to my right must have misspoken because the statute says nothing about being affected by TPMs. That's what it said in the Commerce Committee. It was changed when it went to the House floor, and now it says prohibition. And in conjunction with that, that's when that was the circumstances surrounding the issuance of the manager's report. Now, it's interesting that in its submission, that textual change was something that was, I don't think, mentioned in the Harvard submission. And that is in my mind at least, was a fairly significant omission. With respect to the influence of the manager's report itself, I would refer you to Sutherland on statutory construction, 4814, which has a nice summary in case law and so forth of the statements by the managing committee member and the deference that is ordinarily applied. Obviously, it's statutory construction, so that's not, you know, it's not not absolute rules, but the general rule that in my mind, the office properly applied in this case is contained there, and you may find it useful.
Thank you. Mr. Turnbull?
A couple of things. First, I'm also puzzled on the statutory background because and recognizing that there were changes made later on, and as it was just mentioned, the core of sort of what are supposed to be the elements of the regulatory proceeding came out of the Commerce Committee, and the Commerce Committee, I think what Mr. Williams quoted before was straight from the Commerce Committee report, not the statement of managers. And so I think the distinct verifiable and measurable impacts, that the repeated emphasis in that report on the need for evidence that was the committee that created the process. Now, the process was changed a bit and moved from the Commerce Department to the librarian and the Copyright Office and that sort of thing. And in that regard, it seems to me that the Congress actually spoke and said that the Commerce Department role was to be advisory, and the librarian, upon the recommendation of the Register of Copyrights, was to be definitive. And so the fact that NTIA may disagree about something is not dispositive of anything other than the fact that they're an advisor, not the decision maker. And on the, yeah, I think that was the point I wanted to make. Thanks.
Okay, thank you. Just to give Ms. Cox.
So I just want to talk a little bit about the preponderance of the evidence and what that means. Because in past rulemaking cycles, when the groups that represented blind organizations, blind individuals who wanted an exemption, they went forward, I think this was the 2006 rulemaking cycle, and said, these are the number of books that we have looked at and that we are unable to access via text-to-speech or, transform into some accessible format. And the joint reply comments from rights holders like AAP, MPAA, RIA, SIA, and others, Authors Guild, they basically said that the submissions did not give any indication that the exemption had already been used, and that it was difficult to evaluate in the absence of any evidence about the extent to which the exemption had made things better. And I think that some of the difficulty around bringing forward this evidence and meeting that evidence burden is a confusion on what evidence is needed. Like, do you need to show that by preponderance of the evidence that the past exemption has made things better? Because it's extremely difficult to get that evidence in certain circumstances, such as for the blind. I think that it should be enough to show that there are a significant number of literary works out there, that there are literary works that the blind people wanted to be able to access and they were unable to do so. So that touches both on what the evidence standard should be, but also just going back to this process that it's extremely long and hard to get all of the evidence needed to put these submissions forward.
And in the example that you gave for assistive technology for the blind, I mean, this might be something where if you had a separate or a different track for renewals, that might resolve that.
Absolutely.
Correct?
And the Breaking Down Barriers to Innovation Act would grant renewal of these previously granted exemptions without, unless there's some showing that things have changed. And I think that makes a lot of sense, and I know will be discussed in the next panel. So I've been trying to stay away from that.
Thank you. I'm going to let Mr. Williams get a chance to respond to the responses to him. So.
Thank you. I'm not going to respond on everything. Just Bruce and Chris are right that I quoted both from the Commerce Committee report and from the manager's report. And I think the manager's report is completely valid legislative history, but even if you don't like that report because it disagrees with your position, there are other reports that take the same position as the manager's report, and the office has noted that. On this issue of likely non-infringing, it's two issues. One I've already mentioned, which is that I think the modifier in the statute, it says likely to be in the succeeding 3-year period adversely affected. And then it doesn't again say in their ability to make likely non-infringing uses. It says in their ability to make non-infringing uses. And a judge doesn't tell you this is likely what the law is. The judge says this is what the law is. And I think that's the standard that was called for here. The office has taken a different approach, but I don't think there's anything for the proponents to criticize because the office is already interpreting it to say likely non-infringing. To take it a whole step further and say that the copyright owner needs to come in and show that there is an adverse judicial precedent against their position in order to succeed in the rulemaking just completely upends copyright law, because the default in Section 106 is that if you're making a copy, if you're adapting a work, et cetera, you're committing an act of infringement. You then have an affirmative burden to prove a defense, such as fair use or one of the other exceptions. And so I don't see why the standard would differ in this context. That's all I needed to say. Thanks.
Okay, thank you. I think we'll call on Professor Tushnet and Professor Deckerney and then move on to a new question.
So thanks. I just want to make a comparison to the statutory interpretation issue. Consider copyright preemption in Section 301. So there, the statute was changed after the report came out, and courts have again and again and again agreed that the legislation is not helpful because of the material way the statute was changed between the time the report came out and its enactment. And it's actually exactly the same here. When you say that Commerce became an advisor and not the decision maker, it's not a trivial change. It's actually a complete change in not only what branch of the government is making the law, but also the fundamental underlying orientation of the decision maker and what it's trained in doing. So I do not think that reports about the statute that isn't the statute we have are actually helpful either way. I think we end up with the text of the statute. And then also just in terms of what Mr. Williams just said about upending copyright law, I feel like we spent the last session saying, but wait, this isn't about copyright law, this is about access. So if in fact the question is, will making access, or getting access, allow me to make a non-infringing use, there's nothing upending about that at all, because at least some of these accesses, like the ones that the people I represent have, are completely authorized. They bought the stuff, they have, they can play it, and so I don't think that this is a question of upending copyright law when the whole point is that this extends far beyond copyright law.
Thank you.
Yeah, back to the preponderance of evidence standard. This is about the question about whether or not it's a measurable preponderance of evidence. And I think we just want to acknowledge that often what we're talking about are things that are not measurable. And so we have anecdotes, but we're talking about the degree to which someone needs one media versus another for the same activity. We might all agree that making a remix video or non-commercial video is non-infringing, but what is the level of quality that's needed for that non-infringing use? I'm not always convinced that that's something we can measure. It's something we can argue for, but I don't know that it's ever measurable, except with a lot of anecdotes.
So a new question I want to just take in a different direction is whether or not the triennial nature of the rulemaking is something that should be re-examined. Is 3 years too long, too short? Any opinions on that? Is it working for everyone? Mr. Pendroni?
So I'm going to go ahead and have my cake and eat it too.
Okay.
I will point out that it's both too short and too long. In the case of advancing or dealing with advancements in technologies and new issues, as I mentioned earlier, someone had brought up to me the point that consumer appliances aren't covered, and they discovered a bug, and they weren't sure if they were legally allowed to fix the bug in this consumer appliance based on the current rulemaking, and they'd have to wait for 2 years to bring an exemption. On the flip side of it, as a proponent, having to come back, and this again is going to necessarily key into the renewability discussion in the next panel, is that 3 years, you end up having 2 years to use your exemption, 1 year to then deal with the cycle. And I understand that places a similar burden on the office, that 1 out of every 3 years, a large number of staff have to be devoted to this one particular project. And I recognize that. But how you square that circle, I'd leave that up. I would point out that it is both too long and too short depending on the particular problem you're trying to address. So I don't think that there's a one-size-fits-all necessarily solution here of a particular term.
Thank you, Mr. Williams.
Thank you. Yeah, I mean, it's a hard number to come up with if you're looking for something perfect, but if you're looking for something that's good, that makes sense, I think 3 years works pretty well. A lot can change in that period of time, especially in this current environment of rapidly evolving technology, but it also doesn't mean that you're ending the proceeding and starting it again the next day. So I think 3 years has worked pretty well, and I wouldn't shorten it, certainly, because it really would just mean that we are all constantly working on the proceeding, and there's no time for the exemptions to take hold, settle in, and let us look at them and see how they're working.
Thank you, Mr. Moore.
Just the current statutory term is, from our perspective, is fine. And I would just resist the premise that just simply because a change has occurred, that there's some need to tinker with the premise of the statute, because I think that's lurking a lot behind the scenes in a lot of these discussions. There are a lot of folks who don't like the premise of that statute, and that's fine. We do, and we think it's worked exceptionally well. There is a safety valve, that's this rulemaking, and we think the statutory term is an appropriate way to examine any problems that might arise.
Thank you, Ms. Cox.
Once again, I agree with Mr. Panjwani that, it can be both too long and too short, but I think a way to kind of resolve this is that when there is a need for, you could have a shorter period for a new exemption, for exemptions that haven't been considered before or haven't been granted before, so that you can keep up with the advances of technology, all these new technologies where you find that you actually do need a new exemption and it wasn't considered previously, or there wasn't enough evidence to grant that exemption. But if you had permanent exemptions, or you had, a streamlined process where you didn't need to go through these huge, de novo proceedings every 3 years for educational uses, for assistive technology for persons with visual impairments, I think that shortening that period for new exemptions would make a lot of sense.
Thank you, Professor Duckerny.
Yeah, so that actually sounds really appealing. If there's
Can you turn on your microphone?
That sounds really appealing if there's, I don't know what it would look like, but if there was a different time frame for new exemptions versus renewals. I just know towards the end of the last rulemaking, bibliographic scholars came to me with a great problem, and I said, I'm sorry, it's actually 4 years until that can be addressed, but it's an important one. And in educational context, that can be a long time. It's the entire education of a lawyer, right? 3 years, or at least the school education. Yeah, so if I can just suggest something that's really, really practical, but I think would be helpful, is to recognize that it's law school clinics which do a lot of the representation for the proponents, and if there were just ways of thinking about that calendar, the academic calendar, in the context of the rulemaking, I think would really help. Many, many times I work with the American University Law Clinic, but then the questions we get after the hearing or some other part of it falls outside of the academic calendar, and that complicates things.
Yeah, and that actually was the next line of questioning I wanted to bring up and open it to everyone. What are, if we stay within this sandbox, we've obviously talked about, ways to change the sandbox, but if we stay within the sandbox, what are reforms that the office can do to make the process work better? Believe it or not, we tried to be cognizant of the academic calendar, but academies are not always on the same schedule. But so how would it work for law clinic schedules? What about issuing post-hearing letters? Are the hearings themselves that we conduct helpful? Should there be in more cities? Should it be handled differently because it creates travel expenses, et cetera? So if you, I think originally last rulemaking, we started it in July was when the petitions were due. And then, is that right? And then, or at least if you wanted to suggest a timing that you think would work with the academic calendar, we would be grateful.
Sorry, just anecdotally. So if this were 1 week earlier, the AU students would have been in session, but now they're not. They're still here helping, but
right. Mr. Williams?
Sure. So I think there were kind of two parts to that. First, on the academic calendar, I think it would be great if the hearings could take place when the students who have worked so hard on this proceeding could appear and make their case. I know we've heard a good bit today about how burdensome the process is, and I don't mean to make light of the amount of work that goes into it, but I think it's fantastic that a lot of really great young copyright lawyers are getting to sink their teeth into this during law school, and if they got to show up and do some oral advocacy at the hearings, that would be great.
And would that be spring or would that be summer? I mean, more practically, what does that mean, I think?
Sure. I think the problem now, and I'm not currently teaching it, although I have in the past, is that the hearings come just after the students have left for the year, I think is the problem. But I'll let the professors speak to that. The other issue that I think you raised is, are there any other ways to improve either the hearings or the process through the post-hearing letters? And I mentioned earlier, we'd love to see some kind of drafting approaches at the end of the process. And in the past, when I've raised that, I've been told that there's just no time, and I do understand that's a real concern. But I think, given there is already a period for post-hearing letters built into the process, that if the drafting issues were just presented to hearing people who appeared at the hearing, it could fit into that window. We could get a chance to give you some feedback, and I think that would be really helpful. And then on the hearings, I think they are often very, very helpful, and I think they are really run quite well. One issue that we do run into is, as we said in our comments, if we're preparing a fact witness to come in and give testimony on one issue, but it relates to, every way really that a movie studio uses access controls on their content, it's relevant across all of the different proposals. And so last cycle, I think in an admirable attempt to kind of make sure that each proposal was its own record, it was unclear to us whether the office could look at the testimony from this proposal, the hearing on that proposal, and then use it when considering a different proposal. And I think that harm goes both to our side and the other side, where the proponents shouldn't necessarily have to have the same person who might be a small business owner or whatever else show up at multiple hearings. So I think that would be a helpful change across the board. And then just a little bit of additional clarity on exactly what type of evidence can be presented for the first time at a hearing. I've never quite understood what the rule there is, and it would be helpful to clarify it, I think, because sometimes during a hearing, a witness will pull out their laptop and say, well, I'm looking at this new website, and isn't this a great piece of information? Other times it's been a little bit more like, well, if you didn't put that in your comments, you shouldn't be bringing it to us now. I think both approaches have ups and downs to them, but it would be helpful to know just which rule applies. Thanks.
Thank you. Professor Tushnet?
I would, again, in terms of how you can make this better within the current sandbox, again, point you to the Cyber Law Clinic suggestions, which I think are quite detailed. I also want to pick up on something that came up in the first panel, again, talking about how access is special. So I think we have to recognize that at this point, access and rights controls have been merged by actors making strategic use of 1201, so that the balance that Congress did intend in distinguishing access from rights controls is now gone. So remixers, for example, and educators have lawful paid-for access. What they need is the ability to make their fair uses. And the problem of the merged access rights control, which the Copyright Office has repeatedly acknowledged in these proceedings, you actually could recognize that as another factor. So in the statute, it says other factors that can be considered. The deliberate merging of a rights and access control should count as another factor justifying an exemption. And this would work both within the traditional copyright categories and outside them. And I will point out just here, Congress was envisioning perhaps the celestial jukebox. It was definitely not envisioning the celestial fridge or the celestial tractor.
Thank you. Ms. Green?
So one suggestion that we have at OTI that might help to make the rulemaking a little bit more accessible would be to create a process whereby proponents of exemptions would be able to submit confidential versions of their comments. Oftentimes, particularly in the context of security research, but also in the context of other proponents seeking exemptions, the proponents of the exemptions will withhold certain critical information because they either fear legal liability, they fear that they may be divulging confidential business information, or as is the case with security research, they fear that they may be divulging information that could lead others to identify and then exploit vulnerabilities. And so by instituting a process that would enable confidential versions of comments to be submitted, it would not only make that process more accessible and ensure that the Copyright Office had all of the evidence that they needed to make a complete decision, it would also institute a process that's in fact in keeping with other federal agencies such as the FCC.
And so would your proposal be that confidential information was entirely just delivered to the office, or would sometimes you'll see like dual versions. You'll have the public version and the private version. The public version may describe in broad terms but not disclose specifics, or how would you envision that working?
Yeah, I think that it's important for there to be full public discussion about sort of the broad parameters of what some of this type of confidential information would touch upon, but in order to really respect the need to maintain certain information's confidentiality, you would have sort of that public version that might be more general, and then the very specific confidential version that could be submitted directly to the Copyright Office.
Thank you. Mr. Turnbull?
Yeah, I wanted to comment on a couple points. One, on this last one, on the confidentiality submission, I don't think we'd have any problem with that. We would want to urge the office to institute something that's done in other agencies, an administrative protective order or something, so that counsel and potentially expert witnesses for the other side could get access to the confidential version. But again, it's done in recognition of the kinds of concerns that were expressed, so it doesn't sort of expose it to the public, but it does allow a response, potentially confidential as well, and there are a number of precedents for that. In my former life, I was a trade lawyer, and that happened regularly. I did want to comment, and if you're going to get to this later, I'll hold. But on the access point that Professor Tushnet has made a couple times, a couple things about that. First, the access that is granted, for example, in a DVD or in a Blu-ray context, is to that content in a particular context, in a particular form, in a particular format, and under the rules of the system that are operated. So although the content is, if you will, in the clear when it's presented on the television set, it is not in the clear in a usable way in the system that it is made available to. So to say that we own it and we have access to it is correct only in the sense that it's visually accessible. And if you want to use a camcorder or something at the television screen, go for it. But that doesn't. In a couple of the prior panels, that was used as an alternative for the particular proposals that were made, and we represented for the fair uses that were alleged. But that's one point. So the access that's granted is not generic. It is particular. The second point is that in the statutory structure, it's clear that Congress contemplated this rulemaking to deal with the uses of the content in the context of the access control. I mean, that's why the rulemaking is in the 1201A context and not in 1201B. And so it seems to me that the comments that were submitted, and you may hear more about in San Francisco, but are raised, I think, in Professor Tushnet's comment, are mischaracterized the nature of this proceeding. This proceeding is about uses and in the context of access control.
Mr. Williams?
Thank you. I agree completely with what Bruce just said, and I think it's wrong to think that Congress did not anticipate that some TPMs would constitute both access controls and copy controls, and that's why we're here for these proceedings. But Congress did not conclude that in every case that means that an exemption should result. Congress created the proceeding to say that if there is an instance where something is both an access control and a use control, and a question is raised about whether that inhibits a lawful use, you go through the process that's laid out in the statute, you apply the factors, you see if there are available alternatives, et cetera. And so I think it's a bit of a red herring to say that some merger of access controls and use controls has created problems that were unanticipated. I think they were anticipated, and that's what the proceeding was created to do. I also, like Bruce, would not have a problem with confidentiality. I think we might also at times benefit from filing some things that we'd like to keep out of the public eye, but I would also urge that counsel and maybe even certain in-house counsel be allowed to see the submissions. Thank you.
I will say on the confidentiality, that's something we're certainly going to look at in the study, especially since it seems there's not an objection to it. But one thing I will say on behalf of the Copyright Office is the 3-year rulemaking is a much quicker pace than what some of the other federal agencies do. So we would want to avoid recommending some change that would cause a year of fighting over the protective order.
I'd just like to switch gears and raise another topic that was the subject of a lot of discussion in the comments, and that's the statutory language referring to such other factors as the librarian may wish to consider, and the role of non-copyright issues as part of the rulemaking. You know, we heard from several commenters arguing that the Copyright Office should not properly consider these types of issues and should leave them to other agencies. I think, and we also had some discussion about sort of the process that should involve, whether it's within our authority to affirmatively reach out to other agencies or whether under the statutory language we're limited to consulting with NTIA. So we'd appreciate your views on sort of on the proper role of other agencies and how we should go about consulting with them on issues within their jurisdiction. Mr. Moore?
Again, I would go back to the concept of the administrative record and the breadth. And I think so long as the things on which you rely are publicly disclosed, I think you have a fair amount of leeway to amass information from different sources. But when you issue the rule, you have to explain, yes, we saw this, and I think there probably has to be some opportunity for public comment on whatever was received. But outside of that, I think that was exactly the right approach, was to get information from people who are experts in particular subject matter that the Copyright Office is not, and weigh their views, even if you didn't completely agree with them all the time.
Mr. Panjwani?
It's been our perspective that the other factors that the librarian shall consider factor is directed at the fact that the proponents of an exemption must prove something beyond copyright itself, which would be non-infringement, in order to justify adverse effects, and that allows the librarian to consider additional harms experienced by proponents in determining whether or not an exemption is warranted. In the last proceeding, we had, of course, this interagency process and its consideration of many other factors, and it's been our perspective that this is not really necessary in the process of determining whether an exemption is warranted. This is a question of whether copyright liability will attach for certain activity. And I don't think that the technological protection measures were considered as a policy panacea for any consideration under the sun, whether that be product safety, whether that be emissions, whether that be medical devices. I think there's often a conflation of, there's software in here that implicates copyright, therefore there's something different now, whereas a lot of these devices have existed and these concerns have existed in a mechanical, non-software, non-copyright implicating way, and law and policy is developed to address those issues historically. I think the car example is a great one in which, there's concerns about, well, people could modify the software on their car to allow them to violate emission standards. People have been modifying their cars for a century, for as long as there have been cars. And there have been rules against that. We have annual inspections of cars to check for emissions and things like that. I think most areas of law have already responded to the concerns that we've brought up. And, I admire the Copyright Office for thinking afar and realizing that a lot of these things are implicated by software now. I don't think that this proceeding is the appropriate venue for addressing those concerns.
So just to be clear, taking the last rulemaking as an example, we got a petition that referenced, I think this was sort of more broadly to the Internet of Things, and there wasn't a lot of specifics as to what they wanted to do, but examples of, I'd like to hack the subway system, I'd like to hack the nuclear power grid, I'd like to hack automobiles. I mean, should the Copyright Office entirely ignore whether or not there is a potential public safety concern?
I believe hackers will hack those things if they are malicious, regardless of whether or not there's a 1201 exemption for it.
Sure. Mr. Williams?
Thanks. I just quickly wanted to reiterate what Alan Adler and Troy Dow said in the last panel, that you have to be really, really careful about what constitutes a core copyright concern. That term, it would have to be very carefully defined to have any real benefit, and that there is this distinction, as Professor Tushnet articulated, between access controls and copy controls, and it's clear that Congress did intend to protect access controls for their own purpose as access controls to prevent unauthorized access to works that are available for subscription or on-demand availability. And one fact pattern that I think demonstrates the importance of that clearly is if you've got a work that is available and it's protected by an access control and it's also protected by a completely separate copy control, if you were to hack the access control and gain copy and gain access to the copy, you could watch the movie, you could listen to the song, you could read the book. If the copy control remained in place, theoretically, there's no nexus to even a possible infringement, and then there would be no violation. I think Congress clearly intended to prohibit that conduct, so I just urge you to be careful not to undo the current statutory construction if you start thinking about ways to address so-called not core copyright issues.
Okay, thank you. I think we have about 2 more minutes, so this will be sort of last call. Professor Duckerny?
Really quick point. The one that was made in the last panel is that all of these determinations often will cut both ways. When talking about public health, we thought that hacking your own devices was the issue about public health during the hearings last round, and it turned out later, we found out right briefly afterward, that actually it was the companies that made the cars that may have been causing public health by not allowing hacking. The same thing's true about fair use. We always think commerce is going to favor the people that want stronger TPMs, but actually there's a tremendous amount of commerce which is enabled by fair use and hacking bypassing DPMs. Yeah.
Thank you. Mr. Turnbull?
I just want to say quickly that as the representative of 2 of the TPMs in wide use, our interests, and I think the Copyright Office has taken those into account under this other factor, have to do with the integrity of our licensing system, which is not necessarily copyright, whether the particular thing is a copyright infringement or a fair use or whatever it is. It has to do with whether the overall system can continue to exist, and the benefits from that are to the copyright system and the using public as a whole. And so as a more generic point, I'd say that as you address the things which are sometimes called not core copyright, you need to be really careful because, again, sort of eliminating other factors would potentially eliminate things that we think are important for you to consider in the context of expressive works.
Thank you. Mr. Panjwani?
I just wanted to return very quickly to something that Ms. Green and Mr. Moore were talking about earlier regarding the importance of the role that legislative history has played in the interpretation of how we go about this rulemaking, which is that, while Mr. Moore is correct that there are certain approaches for interpreting legislative history, more generally in the specific case of the House Manager's report for the DMCA, there have been specific criticisms as to how or what value it adds to the interpretation of the law. Her use of the word substantive, I think, was a reference to the substantive diminution language from that report. And in particular, I would just point out that Professor Nimmer, in his law review article generally on the importance of legislative history, taking the DMCA as an important case, specifically calls out the manager's report as a report that does actually offer very little from his perspective in terms of how to appropriately interpret Section 1201.
Okay, thank you. I think with that, we're concluded. We'll take a break for lunch and come back at 1:30 for panel 3. Thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.